Good morning, everyone. Welcome to FEBE. Another beautiful day. Can't believe August is almost done. What happened to summer? We blinked. So thank you to Dunkin' Donuts for providing us with coffee and tea and all their wonderful refreshments. And today I have the honor of introducing Catherine Perales. We know Kathy. She's been to several of our FEBE meetings before. If you haven't had a chance to meet this delightful woman, then what are you waiting for? She's going to speak today on into the must-knows of intellectual property. And Kathy has been a patent attorney, and she has been in that business for 2 years. So she's going to give us all the details of intellectual property as well as some of her background. So without further ado, Kathy Perales.
Thank you. Lisa wanted me to tell you a little bit more about myself, just real briefly. I'm also licensed in Texas as well as Ohio, and that's been since 2000. So I used to be a general practice lawyer, and I opened my own firm way back then, which didn't go so well. So when I opened my own firm here 2 years ago, it's going much better. So if at first you don't succeed, try again. Anyway, so we're going to talk about the must-knows of intellectual property today. I can't talk about everything. And I would love to have questions. If there's certain things that you all are interested in, please go ahead and raise your hand and get the mic, and we can have the question right away, or we can wait till the end. I'm going to mainly talk about patents, trademarks, and copyrights today, even though that's not everything in intellectual property. And as a lawyer, I have to have this as my first slide, my disclaimer. So even though I'm a lawyer, this is not personal legal advice. It's information that can help you. And also, by listening to this or by even asking me a question, that doesn't establish an attorney-client relationship. But I would love to meet with anybody who would like to talk about questions that you have. All right, so what is intellectual property? Sometimes I tell people that's what I work on, and they have no idea what that is. It's basically ideas that are your property. You can buy and sell. They have value. A lot of things are intellectual property. That doesn't necessarily mean that they're protectable by the law. So you can see a listing here of some things, examples that are intellectual property. So the reason that we have intellectual property and why some things are protected by law is because when the Founding Fathers wrote the Constitution, they realized that certain ideas are really useful for society, as well as the fact that it takes a lot of time and effort and money to invent things, to write books, to write songs. And if we want people to be doing these kinds of activities, we need to allow them to support themselves while they're doing these. Some people may just do them as a hobby, but you know, if you're sitting there inventing things or writing novels, you probably don't have time to go work at the grocery store and support your family. So Congress realized that they wanted to be able to have inventors and creators benefit from their creations. However, also, they don't want necessarily people to be able to keep these ideas for themselves forever. So that's why you see that people's exclusive rights to their respective writings and discoveries are only for a limited time. So this is the basis of a lot of intellectual property law. And later on, you may see that different ideas are protected for a different amount of time because Congress decided for good reasons. So we're going to talk about copyrights first. I chose this one first mainly because I'm sure that everyone in this room has some copyright rights, even if you don't really know that. And that's why I put this example of my 3-year-old cousin's thank you note drawing that she sent to me. So anyone who has ever drawn a drawing like this, written a poem, written a paper in school, if you made a website, if you took a photo, you have copyright rights in these things. So copyright law protects literary and artistic works, which includes all those things I just mentioned that probably all of us have created. Also, since maybe you didn't even know you had copyright rights, that's because it's automatic protection. You don't have to do anything. All you have to do is create it. It used to be that you also had to publish it, but that's not true anymore since 1989. Your copyright rights, regardless of whether you register them, last for your lifetime plus 70 years. Or sometimes a corporation or some kind of organization can have copyright rights, and they don't have a lifetime. So that's why we have this 95-120 So if a copyright is owned by a corporation, it's either 95 years from publication or 120 years from creation, whichever is shorter. And finally, even though your copyright rights are automatic, you can also register them with the U.S. Copyright Office. And this process is the easiest process of the three that I'm going to talk about today. Much easier and cheaper than registering for a patent or a trademark. Any questions?
Does that cost money to register a copyright on this website?
The question was whether it costs money to register your trademark with the U.S. Copyright Office, and yes, we're going to talk about that in 2 slides. So we've talked a little bit about what is copyrightable. There's a list there on the left-hand side from the statutes. That list is not necessarily exhaustive. Different kinds of art and creations are created all the time, especially these days. So there may be some things that are copyrightable that are sort of hard to fit in those categories. But I mean, web pages is one. Maybe it probably makes more sense to talk about the things that are not copyrightable. So, for example, a work that has not been fixed in a tangible form of expression. What that means is, let's say this speech that I'm giving right now was not being recorded and nobody wrote it down, then that sort of goes poof off into the atmosphere and you can't copyright that because there's no copy of it. Okay, so, or if I play a piano song, I make up a piano song at my home and nobody records it or writes it down, that's not copyrightable. If I write it down in music or if I record it, then that recording would be copyrightable. The second thing is titles, names, lettering, things like just really short words. Sometimes some people ask, oh, can I copyright this little slogan I want to put on a t-shirt? No, it's too short. Things have to be a certain length in order to be considered literary or artistic work, though you may be able to protect something like that with another aspect of intellectual property law. The third thing, discoveries, principles, concepts, ideas. These types of things are not copyrightable in themselves, though of course if you write a paper about something you've discovered, then that paper would be copyrightable. These kind of ideas are probably more protectable by patent law, which we'll talk about later. And then finally, the last category is things that are not original. So for example, a calendar, like your school calendar that has all the events on there or your birthdays, that wouldn't be copyrightable. It's just public information, not really creative, not considered literary or artistic. Questions?
Isn't Super Bowl, what is that? Is that copyrighted or is that's something?
That's trademarked,
Trademark.
which we'll get to in a minute.
Okay.
Okay, so how do you protect your literary and artistic works? The easiest thing to do and the most important thing to do is to put a copyright notice. So there's an example on the screen. All you have to do is on your website, at the bottom of your brochure, whatever it is, you put the little C in a circle, the year when you created it, and your name. So anybody who looks at that is on notice. Yes, this person created this thing, considers it their copywritten material, and I can't say now, oh, I didn't know who created it. So this is a useful thing. You really should be putting these on your websites in particular, which I think is relevant for this audience, but photos, anything that you think might be copied. Any questions about that? And then next, should you actually register your copyright? If you can see here, the cost is quite minimal, the filing fee. You can do this online. There may be extra fee. If you actually wrote a book, you send in a copy of the book by mail. It takes 6 to 8 months. It's quite an easy process, and you're going to get your copyright registration unless you've made some sort of mistake or the thing that you've sent in is not copyrightable for some reason. The reason why you might decide to spend this money and take this time is if you really think that this thing that you've created has value and there's a good chance that someone's going to try to copy it and use it and make money on it, and you really might decide that it's worth it to sue them. Because if you're going to sue someone for copyright infringement, it must be registered with the Copyright Office. Now, you don't have to register it before the infringement, though it would be a good idea. You can register your copyright all the way up to the end of the term, which is life plus 70, so you have a lot of time. As you can see, if you do it earlier, then there's a few benefits that you would get in your litigation. So it's just something to think about. If you have a website, you may decide to register that if you have content in there that you think people are going to want to lift, or photos, things like that. One thing to think about with your website is if you update a page, then you probably need to file it again. So whenever it changes, you would want to refile your registration if you've decided that's worth it for you. And then these are just some other issues about copyrights I'm not going to go into in detail unless anyone has specific questions. The first thing is sort of unique to copyright law. Independent creation is not infringement. What that means is if I write a poem and somebody over in California writes the exact same poem and they didn't look at my poem, that's not infringement. If you created it yourself, you still have copyright rights. So it's possible that two people or more could have the same copyright rights in the same thing because they created it independently. That's quite different from the other types of intellectual property law we're going to talk about. Fair use has to do with when you're allowed to copy and without permission, and that's a balancing test that is relatively complicated. For example, let's say you have a nonprofit and you want to cure cancer and you really like this John Lennon song and you want to change the lyrics to be about cancer and be inspirational. That's not fair use. You can't do that without permission. It just doesn't fit under the balancing test. Now, on the other hand, if you are a comedian and you do political commentary and you want to change the lyrics to a John Lennon song to talk about the song or just some political event, that would probably be allowed because that's considered a First Amendment free speech. You're allowed to comment and talk about things. So those are just some examples. So normally, if you want to use someone's copyrighted work, you have to get their permission. One useful thing to help you out is that copyright infringement is a federal crime, so sometimes you can get the government to help you out if someone is copying your work. And finally, work for hire sometimes is relevant to people. They wonder, if I hire someone to create my brochure or my website, does it belong to me, does it belong to them? The answer may not be what you expect. So the lesson from that is that when you contract with someone to make something for you, you need to read that contract and make sure it says what you want it to say, because the default law may not be in your favor. Any questions about copyright?
What do you mean when you say the default law might not be in your favor?
Okay, the doctrine of work for hire, it says that the creation belongs to the creator unless they're your employee working in the scope of employment. In that case, what they create belongs to your company. Or there's a certain list of things that if your employee creates, but you have a contract saying that they're assigning it to the company, then it belongs to the company. So really the first one is what matters. So if you have an employee creating something, then what they create, the copyright will belong to your corporation or to you. But if it's an independent contractor, it won't. So you need to be careful with that and read your contracts. All right, well, we'll move on then to patents. This is just a drawing of a patent that was granted in 1939 that I thought looked cool. It's some kind of plastic extrusion machine. So patents protect new and useful inventions. They're pretty hard to get. Quite expensive, and it takes a long time. There are a lot more requirements, at least it seems to me, for patents. Back in 2013, there was an important change. It used to be that the first person who invented something had the right to the patent, but they changed it. Now it's the first inventor to file. So whoever files first, it used to be that if two people happen to be inventing the same thing at the same time, which happens because technology progresses and people might be working on the same project. If one filed first, but the other had perfected it first, then the person who perfected it first would win. But now, no, that's not the case. Now, sometimes someone might steal your idea and they're not actually an inventor, so if they file first, hopefully you can get your rights back, but it wouldn't be easy. So it's more important than ever now to file your application as soon as possible. Patent rights last for 20 years from the filing date. Sometimes you can extend that depending on if the patent office has lots of delays, but it depends on just them. Design patents is a special type of patent that lasts for less time, 15 years. And if you have your patent granted, there are some maintenance fees, which are quite expensive also. Also, the fees of patents, they vary depending on how many patents you have, whether you're a big company, whether you're an individual. They can vary quite a lot. What can be patented? There is a specific list of things that are patentable. And that is a process, which is a method, a way of doing something. A machine, which is something with moving parts. A manufacturer is something that you make that is not a machine. A composition of matter could be a new chemical, perhaps. An improvement, this is an important one, because if you make a really good improvement to something that already exists, then you can patent that improvement. You can actually patent a plant, not any plant, not a plant you just find. It has to be a kind that you bred and is propagated asexually, so you take a cutting, you can't just patent any plant, but some people can patent plants. And then design patents are like a whole other animal. It has to do more with how something looks than how it works. Now, things that are not patentable, all these things trip us up when we are trying to patent things. You cannot patent a law of nature, physical phenomenon. So if you find a new mineral in the earth, that's something you found, that's a physical phenomenon, you can't patent that even though you're the first one who found it, you didn't invent it. An abstract idea like an algorithm, let's say you come up with a new great algorithm in physics or in the computer that allows you to do something much better, cheaper, faster. That algorithm in and of itself cannot be patented. You might be able to use that algorithm in a computer program or in a machine, but that often trips people up, this abstract idea. So the next one, computer program. Sometimes you can patent a computer program, but it has to be linked to a machine, some physical thing. This is a really tricky thing in patent law right now, where the Supreme Court and everybody is trying to figure out what all the issues are and when can you patent a computer program and when can you not. Let's see, data by itself, a human being, you can't patent a human being even if you clone one. You can't patent your company or a contract. Those are not in the patentable list. Questions about that?
Kathy, we have a question.
Oh, yes.
It was saying computer programs, how does that work for companies with like their software? Like you have, like just as an example, Apple with iOS and Android with their operating system.
Yes. So the question was, how do Apple and Google or Samsung or whoever, how do they patent all their software that runs on their phones or their computers? And the answer is they write it up just right so that it somehow connects to a specific kind of phone or a specific kind of processor or a GPS or computer. It has to be written up carefully. You can't just copyright your code. Excuse me, you can copyright your code. You can't patent your code by itself. It has to also specifically work with some type of hardware. Okay? Okay. How do you protect your invention with a patent? The most important thing is that the invention must be new, useful, and non-obvious. These three requirements seem simple. They're not always. The invention must be new. You have to file your application within 1 year of inventing. One time I got a call from someone who had invented something 22 years ago and been using it, and no one else knew how to do it but them, but it was not new. So we couldn't patent that. Now maybe if they had recently made a substantial improvement to it, making it work better, could have patented that. But new is important. Useful, it has to be something that does something useful. Even a game can be considered useful, so that one is not usually quite so hard to meet. Non-obvious, this one can be tricky. Non-obvious means that it hasn't been done before, it hasn't been published before. The patent examiners are really good at finding examples, patents, publications, magazines that they can combine and say, oh, well, if you just got this article and this patent application and put them together, then it would have been obvious. so your invention is obvious and we're not going to grant your patent. That's what a lot of patent rejections are about. It's really important, in my opinion, to keep your invention secret for many reasons. Now, in the US, you are allowed to publish information about your invention, and then you still have a year to file your patent application. In other countries, that's not the case. So if you were thinking of patenting your invention in other countries, you definitely would not want to tell anybody about it before you file your US application. Also, there's always the danger of someone else either stealing your idea, or maybe someone else is actually working on the exact same idea, and when they hear about yours, they're like, oh gosh, I'd better hurry up and file my application. So it's really a good idea to keep your invention secret while you're working on it. Use non-disclosure agreements if you have to talk to other people or have employees working on it. Okay, the next one, you only have one shot to get it right for a particular invention. When you file for your patent, you really have to do it right that time. Your application has to include everything because you won't get a second chance. You can't say, oh, I messed up, let's try again. To some extent, you can amend your application, but not very much. So it's not something that you want to do lightly. Sometimes it's difficult to decide when is the right time to file your patent application because you may be continuing to make improvements. Now, the purpose of a patent, some people, they have an invention and they really want a patent because then they can stop other people from doing it. And also, having a patent can really increase the value of your business. On the other hand, they don't really want everybody else to be making their invention, and they don't really want everybody else to know how to do it. But if you're going to get a patent, your patent has to teach people exactly how to do it. You can't really hold anything back. It can't be a secret. In return for getting the right to this invention for 20 years, you have to tell everybody how to do it. So you can't have it both ways. If you decide to keep your invention secret, then you wouldn't want to patent it. You would want to protect it using trade secret law, which is something entirely different. The filing fees we talked about a little bit. These are just the initial filing fees. Depending on whether you're an individual or a big company, it would be between $400 and $1,600, plus more fees down the road. And this doesn't include the attorney fees or the fees that you would incur to write your application, which can mount into the thousands of dollars depending on your invention. And the whole patent application process, if you have expedited review, which you can pay for, then you can possibly get your patent granted in as little as 12 months. Otherwise, though, it often takes several years, and it depends on what kind of invention it is. Some types of inventions have many, many applications, and there's only so many patent examiners, so they just can't get to it. Other classes are faster. Questions? Yes?
When something says patent pending, does that mean it's going through this process?
Yes, the question was, when something says patent pending, does that mean it's going through this process? Yes, that means you filed your patent application. So that will give you some protection, though not as much protection as you might like. Okay, and again, some random more patent issues which I thought were important. When you get your, yes?
Can I ask a question? I'm trying to understand getting that patent, stopping people from, you have this product and they want to make it. You
Yes.
tell them, you have to show them how to make it. Can you charge them a certain amount?
Yes, the whole idea of getting a patent is that you can stop other people from making this thing that you've invented and making money off it. Now, you can say, well, I'll let you make it, but you have to pay me this much. Okay? And so a lot of people, they invent something and they don't actually want to make it, so they license it out to somebody else. Yeah, but the whole point of the patent is that you can stop others from making it, if you want to. Now, it's important to know that when you file for a patent in the United States, that only covers the United States. So you can stop people in the United States from making your invention or selling your invention. You can't stop people in other countries from making or selling your invention in those other countries. China. Yes, China. So if you go to China and you say, well, I have a US patent, they'll say, so what? What can happen is the Customs and Border Protection of the United States, if you let them know that people are importing products that infringe your patent, if they can find it, they won't let it into the country, so they can help you out that way. A lot of people do ask me about filing patents in other countries. It's expensive, it's tricky, but it may be worth it. So you would pick and choose which countries you think are most likely to be infringing on your patent, and you may decide that you want to file for a patent over there. Okay, remember in copyright law, independent creation was okay, but in patent law, that's the whole point, it's not okay. If someone else invents your invention and you have a patent on it, too bad, they don't get to do it. Even if they independently invented it, they cannot make that. There's no fair use, there's no exception where someone would be able to use your patented material. The alternative, trade secret protection. If you don't want everyone in the world to know how to make your invention, you can keep it secret. Some people decide to do that. If it's a process, a method of making something, maybe they can keep that secret in their factory and make sure they have trusted employees. It's just a different method of protecting your invention. Any questions? Yes, before we move on.
If somebody makes something and they don't patent it, and you steal their idea and you start making it and you patent your idea, who's right? Or who's going to win that?
So the question was, if you make something and don't patent it, and someone else sees what you're making and then they try to patent it, was that going to work?
Yeah.
It shouldn't work, though you need to be paying attention, because technically you already made it and it was already out there in the public. So it was obvious, right? So they shouldn't be able to get a patent on that. So if you were paying attention, you could file papers while their patent application was being examined, and you would say, hey, I made this, and here's proof, and here's advertising, or whatever, and that would prevent them from getting the patent. If they did get the patent, then you might have to sue them later, and you probably would be successful, but it sure would cost a lot of money. So that's one reason why sometimes you don't want to keep your invention secret, or as you say, it wasn't even secret, but that's one consideration, because if you have a trade secret, you're using your invention in secret, but someone else invents it and patent it, then you wouldn't be able to do it anymore. So in that case, it wouldn't have been public, so you couldn't stop them.
What was the controversy with Thomas Edison and Nikola Tesla over the light bulb? So, you know, some people are saying that Thomas Edison stole his idea, and Tesla never patented. So I'm trying to figure out with patent, how did that really fit in?
That is a good question, and I don't know the details, but there was probably some dispute about who invented it first, and I'm not sure whether Tesla just didn't pursue it, or if Edison maybe had better documentation. So I'm sure there are books about that, which I would like to read, but I don't know the answer to your question. Yes?
I've heard the concept of, I don't want to file a patent. I would like to, but it's too expensive. What if I just put my idea down on paper, put it in an envelope, and mail it to myself? Then I get my stamp from the post office saying, on this day, I sent myself this letter, so that proves I invented this on this day.
Yes, that used to sort of work when it was first to invent. The first person to invent would have the rights to it, but nowadays it's first to file. So that doesn't work anymore. Since 2013, if you did that, you could prove, well, I invented it before this other person who got the patent, but it doesn't matter, you didn't file. Now, and just by mailing it to yourself, that's not publication, so you wouldn't have that argument either. You wouldn't be able to say that, well, it was out there, it was obvious. Okay, so we're moving on to trademarks now. You can see some familiar trademarks there. Thank you to Dunkin' Donuts for always giving us the free coffee. A trademark is sort of a different animal. It's not really a literary or artistic or scientific creation, but it is considered intellectual property. It's used to distinguish your goods and services from everybody else's. So, for example, if I make donuts, I can't put Dunkin' Donuts on the package. I can't use any of these. You can see the orange and pink, that is actually trademarked, those colors. But those two things in the middle, America Runs on Dunkin' and Dunkin' Donuts, they've actually just trademarked those words. So no one else is allowed to use those words in connection with donuts or coffee or whichever classes that they've registered for. The cost and process of getting a trademark is relatively easy, a little bit harder and more expensive than a copyright, much easier than for a patent. An important thing to remember about trademarks is you have to use it or you lose it. If you stop using your trademark for a while, you lose your rights in it. You have to be using it to have trademark rights, using it on your products or in connection with your service. And a trademark, since it wasn't listed, if you noticed in that quote from the Constitution, so trademarks are not limited. If you keep using it, you can keep preventing others from using it forever. And you do have to, if it's registered, you would have to pay maintenance fees every 10 years.
What is the timeline of use it or you lose it?
How long could you stop using it? Yeah, that's a good question.
Did Trump really trademark the words "you're fired"? Is that real?
I don't know. The question was, did Trump really trademark the words "you're fired"? We could look that up, actually.
I'll look it up over.
Great. Yeah, if you go to the test database, then it'll tell you. Because when you trademark something, you have to pick a class of goods or services that it's in connection with. So I wonder if it's in connection with TV shows or, I don't know. Crystal will find out for us. What can be trademarked? There are some examples here. You saw the words, Dunkin' Donuts, the design and the font that they use. Words plus design. You saw the cup with the DD on it. So a trademark, it doesn't have to have words in it. It often does. It can be plain words, words in a certain font or diagonal, curved, with the addition of pictures or lines. And then there are some things that you can trademark you might not expect. A smell. There are not very many smell trademarks. Apparently the first one was for some embroidery floss that smelled like plumeria blossoms, and they actually got that trademark. So no one else can make embroidery floss that smells like plumeria blossoms. Sound. Oh, here's where I have some examples of sound. So if anyone knows what these sounds go with, you can make a guess. Yes, the Pillsbury Doughboy. It's very recognizable, isn't it? And then this other one, I really like this one. It's sort of long, so we probably won't listen to the whole thing.
Hey, man, who's that cat coming down the street?
I don't know, but it sounds to me like that's Wicked Man with the bone.
Sure having himself a ball.
Let's play this one later. So if you notice, that first one was really short, a little giggle, but this song is 5 minutes long. So I suppose other basketball teams or entertainment groups can't use that song in connection with identifying themselves. And then color. Color is a really tough one to trademark, but it is sometimes possible. Does anybody think of a color that they think might be trademarked? Say it again? Ferrari red.
IBM blue.
Which blue?
IBM's blue.
IBM blue. Well, IBM in that certain color, but they haven't trademarked the color in connection with their computers.
Brown's new logo, orange.
Yeah, well, on their logo and maybe on uniforms. So one that you might think of is green for John Deere, but they didn't get that one.
Golden Gate Bridge.
What?
The Golden Gate Bridge. They have a specific color that they paint the Golden Gate Bridge.
True, but that's not a business. I'm not sure how they would. I don't think it's trademarked. That would be a good one. I don't think that one. The one that is that I found is for Corning, pink insulation. So nobody else can make fiberglass insulation that's that color of pink. They were able to get that trademark. So notice, it's only fiberglass insulation.
That doesn't apply, yeah, the pink only applies to insulation,
Yes.
like the brown only applies to the truck.
If they were able to get, if the UPS brown is trademarked, which I don't think it is, then yeah, it would only apply to their trucks. And UPS provides a service, not a good. So that's one thing I didn't talk about yet. You hear about trademarks. There's also something called service marks. They really have the same law applied to them. Trademarks apply to goods, things that you sell, and service marks apply to services. So for UPS, for example, delivery of packages, we often just talk about them all as trademarks because the law is pretty much the same for all of them. So Chris, did you find out anything?
Yeah, I didn't find anything. At
Okay.
least registered.
So we don't think that Trump registered a trademark for "you're fired."
I didn't check, you could have tried.
Yeah.
But nothing's been registered. The only one with "you're fired" is a do-it-yourself pottery
Oh.
business.
So Chris said there is a trademark registered apparently for a pottery business. So that makes sense, actually.
Actually, Michael Buffer, when he says, "Let's get ready to rumble," that's
Yeah.
trademark. If you're fired, everybody says that.
Exactly.
So when he said, somebody tried to use that and he sued them.
Interesting. Yes. Okay, so let's talk about things that are not trademarkable. And so just because the trademark that you want to use fits in the category on the left side doesn't mean that you're necessarily going to be able to get a trademark on it. So if the trademark that you're wanting to use is confusingly similar to an existing mark, then you won't be able to register your mark. So if there's Coca-Cola, which of course has many trademarks, and you want to have Coca soda or something, that would be confusingly similar. Or even if you had soda that had the same white little swoosh with the red, you probably wouldn't be allowed to do that. That's just an example. Now, merely descriptive. There are different categories of trademarks. One thing that I think is sort of funny is if I buy some bread from Walmart that they baked there, it says the bakery. And they have a little TM next to it. And how can you trademark the bakery? How can you prevent other people from using the bakery? You can't. Okay? I'll explain about the difference between TM and R in a circle in a minute, because that's important. But a name that is merely descriptive, like if I called my law firm the law firm, you just can't use that. Now, if you get more towards something like Apple Computer, Apples have nothing to do with computers, so that would be easily trademarkable. There's a whole range in between. A generic term, this sounds similar, but it's a different concept. Think about Kleenex or Xerox. I'm going to go, at least people used to say, I'm going to go Xerox this paper, and that meant I'm going to copy it. If people start using your trademark as a noun or a verb, just meaning something generic, then you can lose your trademark. So companies that have this kind of issue, like Kleenex, they have ad campaigns saying it's not a Kleenex, it's a Kleenex brand tissue, things like that. So even though you want everybody to recognize your trademark, you don't want them to use your trademark just to mean the product, anybody's product. You just want them to mean your product. Offensive terms, scandalous, immoral terms are not registerable. Not really going to talk about examples there. There is a recent case that you may have heard of about the Slants, who is a rock group of Asians, and they called themselves the Slants because of the stereotype that Asians have slanty eyes. And so the Patent and Trademark Office said, no, that's offensive. You can't do that. And so they filed a lawsuit. They felt that it was not offensive, it was empowering, and they went all the way up to the Supreme Court, and they won. So they were allowed to use that trademark. So offensive, of course, is a matter of opinion, but it is a category that is not supposed to be trademarkable. Yes?
Okay, now here's a question that I had for quite some time. The Brothers Grimm had copied all kinds of stories that were told down the line. Disney came up with Snow White back in the 30s, and I could understand you wanting to protect your version of the movie and character designs. But those dummies went ahead in 2012, trademarked the name Snow White, so now nobody could do anything with it unless you're just doing a literary work. Is that true that they actually can do that with a public domain name that was never theirs to begin with?
So you think they actually, the question was about registering Snow White. So I wonder what class of goods or services it was registered for, because you're right, that seems like something that should be in the public domain. Now, if you were registering Snow White for mayonnaise, then that would make sense, but it doesn't sound like what they did.
There are people that are fighting that right now because of the fact that that was public domain. One person wanted to do a web series of their own interpretation, and supposedly Disney said, no, you can't do it. Can't do it in the form of a play, a movie, anything other than literary work, because supposedly they own the name Snow White.
Well, that doesn't seem right, does it?
Nope.
No. Other questions? Let's see. Oh, the last thing here that's not trademarkable is you can't trademark a person's name without their consent. So, for example, if I wanted to trademark Donald Trump peanut butter, I couldn't do that unless he gave me permission to do that. Now, if I want my name to be on it, then I'm going to give permission, so that could work, possibly.
Would that interfere with like the Tesla company? Like, are they allowed to do that just because it's the last name, not the first name too?
The question was, why can Tesla company use that name? That is a good question. It's probably because Tesla is a historical figure and he's dead, and he can't give permission. I wonder. And also the word Tesla, I think that's that's actually a measurement of something electronic or electric, isn't it? Like charge or something, so it's sort of become a word in the English language, so that also might be why.
Okay.
Other questions? Yes?
How does that work with people that have like the same name as something?
Yes. The question is, what if you have the same name as a famous person? So in that case, it's a little tricky. It's possible that that famous person may already have trademarked their name for a certain product. It's not easy to just trademark your name unless you've been using it in connection with that product for a long time, so it's already really recognizable. So can you think of an example of say it? Hershey's, sure, but how about someone who's alive right now?
Will be coming to America. McDonald's.
Can you think of a celebrity right now who sells things using their name? George Foreman Grills, yes. Now his name, I mean, it's not really that generic. It's not like Joe Smith.
O'Reilly's Auto Parts, would that be O'Reilly's?
Well, I don't know who O'Reilly is, right? They may have just picked that name.
Well, you don't sell anything, but Cheech from Cheech and Chong, I would imagine that name Cheech has to be trademark because of
It might be.
these movies. I'm not sure.
Right.
It even goes by Cheech Marin, so
Yeah. So the George Foreman, I think, is a good example. If your name was George Foreman, you probably couldn't sell grills using your name because that George Foreman is already doing it. And it doesn't seem fair, but I think that's the way it is. Now, if you're just me, and I want to sell Kathy Perales peanut butter again, I could probably do that. Okay, how to protect with trademarks. This is an important point. When you have your business name, you should be putting a TM right next to it whenever you print it anywhere, on your website, on your literature. You can put TM next to your business name or your slogan or your logo without registering it. All that TM means is that you're using this to represent your business and you're putting everybody else on notice that this is my trademark, you shouldn't be using it, at least not in connection with this same type of goods or services. So my advice is that people put that right away on their business cards, on whatever they're using. Update your website. And so If you want to use the R in a circle, that means that you have actually registered that trademark with the U.S. Patent and Trademark Office. And you can do that. You can actually register with the United States office or also with your state office. And sometimes people wonder, well, if I've registered with the U.S. office, why would I bother with the state? One reason is because, I'm getting ahead of myself, but because counterfeiting is both a state and a federal crime. So when people make things and they put your trademark on it and they're trying to pass it off as yours, but they're saying it anyway, counterfeits. The state and the federal government will prosecute people for that. But you would probably have to have your trademark registered in the state if you want the state to help you, or with the federal if you want them to help you. Okay, now one thing that is really different from patents at least is that in order to register your trademark, you should already be using it. It's not completely necessary, but it's really much easier to get your trademark registered if you're already using it. You can file an intent to use application, but it's more expensive, and you actually have to start using it before your trademark is actually registered. So I always recommend that people start using their trademarks right away. It's not something you want to be secret. You want everyone to know what your trademark is, and you want them to associate that with your business and your products. Now, your trademark applies to one or more classes of goods and services. So if I trademark, let's pick a trademark, Apple computer again. That applies to computers. It doesn't apply to lawnmowers. It doesn't apply to legal services necessarily. So you have to choose the classes that you want. And for every class, you have to pay extra. So as you see below, the filing fees are between $225 and $400 per class, depending on how you file it, online or paper. Now, the whole process of registering your trademark it's a little harder than copyright, but much easier than with a patent. And it takes about a year to get through the whole thing. Can be less, can be more. Any questions on that? Okay, and then my miscellaneous slide for trademarks. We already talked about how counterfeiting is a federal and state crime, so you can get help on stopping people from misusing your trademark. Again, like with patents, your U.S. trademark only works in the U.S., your registered trademark. So some people want to try to register their trademarks in other countries too. Though it can be expensive to try to get your foreign trademarks, and there's probably different requirements. This next one is sort of specific, but it's an interesting issue that is causing problems these days. If you're familiar with, if you have a website and you're using Google AdWords to help people's searches come to your site, you can actually put on your competitor's trademark so that if you type in my trademark, it goes to your website. And that is not considered trademark infringement at the moment, even though it sort of seems like it. So the law may change on that soon, but that's just something to know. And finally, I've noticed that when trademarks get filed, you start getting all these emails from services who want to charge you money to do things that don't need to be done. So if you actually do file a trademark, you can expect that. And if you're getting help from an attorney or someone else, you'd want to, if you're thinking about responding to these emails, ask this trusted person first, because you can waste money doing that. So any questions about trademarks or anything at all? This is my last slide. Yes?
I have one. We have a trademark check. This is the guy we're using, okay? But now he's a barcode, okay? However, the actual outline of him, my designer, I don't know where he found him online, okay? And then he went in and turned him into a barcode and put the numbers under him and everything. Do we need to do something else before we trademark that, since somebody else might already have the outward silhouette, if you will?
That is an interesting question. So the question is about this drawing that she has that is a barcode, and she's not sure where the original idea came from, right? So there may be some issues of someone who thinks that they own that. I'm not sure. Since you've changed it, it would be a question of whether It's been changed enough. So you're thinking about trademarking that?
Yeah.
Yeah, which, I mean, it's a sort of a logo. It would certainly be something that's trademarkable, I would think. So that is a good question.
Infringing on somebody else.
It's possible. She asked whether she might be infringing on someone else's trademark or copyright, and it could be either, I would guess. So that is a good question, and more research would need to be done to see the facts, to see where it came from. Chris?
I would say you could do a clearance search. You could pay a company like $700, and then you'll get back a book about an inch thick, and it'll have every person who maybe is using it or is registered trademark for that inch. Then you'll know if it's being used or not.
And that is a great idea, so then you would have confidence. Other questions? All right, thank you very much. Oh, there are sign-up sheets on the table in case you would like a copy of the PowerPoint, but I think Ray is also going to put it up with the video sometime. But I thank you for listening to me.
Last chance. Does anyone have any questions for Kathy? That was very educational. Very educational. I'm thinking of all these incidents in my head that I could have trademarked this or copyrighted that. I'm sure everybody else is going through their things that they've done. So thank you again. Wonderful information. And I like that you used our Dunkin' Donuts as part of your presentation as well.